I'm going to go ahead and start in. And I had two comments before we dive into the section about how do you assert and protect water rights and what are things you can do in front of the board administrative processes to assert and protect those rights. The first is regarding these statements of water diversion and use. I forgot to note that we do post these on the internet. So if there was anything in here that you didn't want to have posted for some reason, everything just automatically goes onto the internet after you submit it to us. So you should be aware of that. I don't know that there would be any sensitive information in here, but if there were, you might want to have a conversation with somebody before moving forward with a submittal. The other issue is about timing. Now, I think I like having questions during a presentation because I feel like it's a way to be engaged and to make sure that I'm hitting the things that are most relevant when sort of the issue comes up. But I think in order to give everything else that's on the agenda today a fair shake, and because I think a lot of the questions that sort of at this point in the presentation are being raised, there's a lot of questions that are more of a generalized discussion, and I think that discussion would actually happen better when we've sort of been through all these concrete steps about how a lot of the questions are about how do we go about doing certain things, and if we can get through the parts of the presentation that are about how to protect your water rights and how to protect in-stream flows, I think that it'll be a more useful conversation. So what do people think about saving the questions more to the end? And then I really think the conversation would be better. Am I crushing anyone? You're crushed. No. Okay.
But you asked a question, I'm going to answer it.
Please do.
That will be helpful and relevant if you move faster through the material. If you spend 15 minutes on the slide, then by the time we get to 5 or 6 slides down there, the question that might have been relevant to that particular slide that you spent 15 minutes on has gone past. So if we're going to do that, there has to be an equitable balance between going through the material, getting to a point where there can be an intelligent conversation, and getting fed material and waiting till the end for replies. See what I mean?
Yeah, so the idea would be to go through and be able to have the conversation at the end.
A little more rapidly.
Yeah, because otherwise I don't know that we'll get through everything by 3. Yes?
I think it would be helpful as people ask questions. I like that they ask as it's coming up. Doesn't necessarily mean they need to be answered at the time, but if one of the staff could write the question down so none of us forget it, then it won't get skipped and not answered.
That's a great idea. Geeta, would you be willing to help out with that? Okay. Excellent. All right. So we're going to march forward and talk about the complaints process. So as I touched on briefly in the overview of what this section is going to talk about, the complaints are a way to let the board know if somebody is diverting water in a way that is illegal, in a way that harms your water rights, in a way that harms the public trust, in a way that doesn't conform with their water rights. Victor Vasquez from the complaints unit, who I don't see in the room right now, is going to be available in the session that starts at 3:15. He'll be standing by we have some poster boards and some space where you can talk individually with people. He is the head of one of the complaints units, and he will be able to talk with you a lot more about the specifics of how to file complaints and where they are in terms of processing them at the division. This is one of the changes we made to the presentation. We thought it would be important after the last presentation to have someone from the complaints unit actually here and available. So he'll be there. We have an online form now for complaints, and it's very simple. You just fill out an online form. They're all centralized at Cal EPA. Cal EPA looks at it, says, oh, this says water. We're going to send it to the water board. Geeta's division at the water board gets it, and she says, this person is talking about something that's about water rights, so we're going to, forward it on to water rights. And the web portal has very limited information that it asks for. And the actual requirements in the water code, in the California Code of Regulations, it's section 820 of the water right regulations, also it doesn't ask for a lot of very detailed information. However, the likelihood of our being able to act on your complaint depends in a large part on how much information you can provide to us. So just because you're looking at this code section, it says, okay, who am I? What's my water right? Where's the violation? How am I affected? What do I want to have happen? And here's how I'm complying with my statements of water diversion and use. That's all we ask for, but we get a lot of these and we have the limited resources. And so if somebody has a lot of information, if somebody says, we think this is affecting these fish, we'll say, okay, there's a claim out there that this is affecting fish, and we might have the resources to take that on and we might not. If you send us a detailed report that says how these fish are being affected and what the status of them is, and how this particular diversion as opposed to anything else that's happening in the watershed might be related to that, the chances that we'll be able to act on that complaint are much higher. Now, I recognize that that's a much higher burden to filing a complaint, but realistically, that is what can help the water board be able to act on something. These are the codified requirements for filing a complaint. One thing I want to just emphasize a little bit is to think about the action that you're requesting in terms of this complaint. Is it that diversion cease altogether, that some kind of monitoring equipment be installed? You can request a specific solution. In fact, we are looking for specific solutions to the problem that you have identified. And if you have ideas about how to fix that problem, then those are going to be very helpful. So we do an initial review. It only gets to the water rights division if it's really a water right issue. And then the state board can turn around and ask you as the complainant or the original water right holder, or typically both, for more information about what's going on. And then in addition to information requests, people from the complaints division can go out into the field and do field investigations. And the state water board can decide to we're going to go over action on the next slide, but we can decide not to act or to refer things to court, or if we decide to act, there's really kind of a broad spectrum of potential actions that we could take. The top one there is voluntary corrective action. Now, what that means is talking with the person to get them into compliance. You know, they are diverting and they don't have a permit. Well, we might go in and say, okay, you know, let's have you go ahead and submit an application, and then we'll do an analysis and see if there's water available and see what conditions you can divert under. There could be a hearing by the State Water Board, particularly if the facts that the complainant alleges and the facts that the water diverter states conflict. A lot of times there'll be a hearing with cross-examination to figure out, you know, to sort of get to the bottom of, well, what's actually going on here? Who's right? The State Water Board can issue a fine. It can issue a cease and desist order that a court can then enforce. And it can go so far as proposing a revocation of rights, which is something that came up earlier. The State Water Board can look at all parties, not just the person against whom someone is complaining, but also the person who's complaining. So if you have a water right, this comes up actually relatively frequently, that someone is alleging interference with a water right, and their own water right is out of compliance also, that's going to come to our attention at that moment. And that will definitely come up. So it's sort of a make sure your own house is in order issue. And again, Victor is going to be available to talk a lot more about how we prioritize things, when we go to the field, how much information we need to get, where the status is on different public trust complaints, and questions like that. This here is an example of a proceeding that was initiated by a complaint. This is the lower Yuba River, and there are people fishing on it. And in 1987, there was a public trust complaint filed on the lower Yuba River that said that Yuba County Water Agency was not releasing enough water. It was damaging the habitat of the fish down below the diversions. Ultimately, that, you know, there was a long period of negotiation where people tried to come to some sort of agreement to resolve the complaint. They did not. It went to a hearing. The board took a very long time to issue a decision. It was a long hearing, a long time to issue a decision. The decision was challenged. The decision was overturned on procedural grounds. There was a second hearing. The decision was essentially reinstated. The decision was challenged in court again. And then a settlement agreement was actually reached. Another round of hearings was held to make changes to not only the Yuba County Water Agency's permits, but a bunch of other diverters in the area to allow the settlement agreement to go into, you know, to become effective. There were still some outlying issues in the litigation. That finally resolved in June. So from a 1987 complaint. So these issues can take a lot of time and a lot of resources to address. So when I say we get a complaint and we have to make a determination about what we can do and whether we can act on it, and that the more information we have, the more likely it is we'll take it up. This is the context of that. This is what action on a complaint can entail. And so the reason it can take a long time to act on a complaint, or the complaint might not get investigated immediately, or you might not get the response you're hoping to get by calling to attention to something that you can see very clearly is a very desperate situation, and there's something very real going on, and there's a clear culpability, a clear causal link, doesn't mean that, and I'm not saying this is necessarily the case with, with the Yuba litigation, but it doesn't mean that from our perspective, we feel like we can easily take a whole lot of things on at once. And so this is not, this is what it is, and I'm trying to give you a realistic picture of what a complaint like this can entail. And then again, Victor's going to be here, and he can talk with you about specifics, because we have decided to commit many more resources to the complaints division than we have in the past. So I don't want to be too negative here. This is ultimately a positive, solution. It did happen as the result of a complaint. But I do want to warn that it does take some time, and it's not as easy as we would hope. And I just want to emphasize again, a complaint does not subject the person complaining to our sort of exercising any kind of direct authority over the complainant. It doesn't result in an adjudication of anyone's rights, and so there should not be any sovereign immunity concerns with that. Similarly, the protest process is another way to engage, and this is in State Water Board, in decisions that are already in front of the State Water Board. So complaints are things that are not in front of us already, and you're calling attention to it and saying, hey, look, this is something that's going on here, and it's about this diversion, and we need to do something. The protest process is for actions that are in front of us already. Somebody has applied to us either for a new water right or to change an existing water right. We have, in most of those processes in front of us, a place where other people who are affected can enter into that process and have their issues addressed in it. It's most changes and all new applications. There are a few temporary changes and urgent changes where it's a less formal process, but there's another way to intervene. They're called objections, not protests. So this is your typical protest procedure. You would get a notice because you've sent us your statement of water diversion and use, and we know that you want to know about actions that are going to affect a particular stretch of the river. Then there's usually, and this isn't, again, there are a bunch of different processes and they all have their own codes, but typically there's a period where the protestant and the applicant or the petitioner try to work things out with you. Is there a way to address this? And I realize that, some conflicts are not going to be, sometimes there's a win-win situation and sometimes there is not. And so if there's not a win-win situation, the resolution period can be kind of pointless because, there's headbutting and there's not a lot of ways about it. But there is this period where you encourage things, and there can be very creative solutions to water right problems that seem like intractable conflicts at first. The board, like with complainants, can request more information, both of the person protesting and of the person who's in front of us with a permit or a license or an application. And if we ask for more information and you don't provide it, then your protest can get canceled. You can get kind of like kicked out of the process for non-participation. It's a very interactive process. If there are issues that can't be resolved through information requests, back and forth settlement, and there are disputed issues of material fact, then there's a hearing. So if there's just a policy disagreement, you don't go to hearing. But if there's a disagreement about what effect will this actually have, then that goes to hearing. Yeah.
Is this the right location to, or is a protest the right place to put the water rights that currently exist, appropriative water rights that currently exist on the water zoning listed species for review of the water rights?
So that would probably be the complaint process. So that's a good question. Let me just go over quickly the difference between the complaints and the protests. So the complaints are somebody's doing something already and there's a problem with it. And the problem can be the situation is new, there's a newly listed species, there's a new effect of an existing diversion, or it can just be something it's been having this effect for a really long time, but that doesn't mean that it's acceptable. And so you can file a complaint about that. A protest is when something's in front of us already. So if you have a listed species and someone's asking us to make a change in their water right in a way that's going to affect that listed species, then that comes up in the protest. But it's because the action in front of us is going to have that effect. It's not because the species newly got listed. It's because there's, somebody's trying to make a change in a water right.
Are the staff there aware of newly listed species? I mean, are they paying attention?
Absolutely. Yeah. Yeah. So if things go to hearing, that can take a very long time, or it can be, a matter of a few months, depending on how broad the range of issues is and how complex the issues are. Here is an example. We get complaints and protests all the time. I don't want to say most things we do, because if nobody gets a complaint, then it probably never comes in front of a lawyer. But very, very often there are complaints about actions. Here there was an application by the City of Davis and the City of Woodland for a Sacramento River, new Sacramento water right diversion, a new application. I think it was about 5-6 years ago. As you can imagine, there were some protests. So, hey, who here has ever had water in Davis? Yeah, it's really tasty, right? I mean, it's horrible. So they get water from groundwater, and it's very poor quality groundwater. It's very salty. And so then the reason they're looking for a new water source isn't just because, they want everyone to be drinking better tasting water. It's because when we got to their waste treatment plant, they were unable to get the water clean enough to dump it into the river without violating the Clean Water Act, not because they weren't cleaning out the water after it had been used, but because the water that was coming into the system was so dirty. So they were having problems meeting their Clean Water Act discharge violations because the water they were using from the beginning wasn't a quality of water that you really want to have in the Sacramento River. And so they applied to get some water for the Sacramento River to dilute their groundwater source so that they would quit violating the Clean Water Act. Well, we talked about the issue of overallocation before. The Sacramento River has a lot of people wanting water from it, and it doesn't have a lot of water left over to give. So the State Water Board many people protested and said there's not water available. I want to be sure that there's going to be water available for my water rights downstream if you're taking some upstream. And there were protests about the potential impacts to fish and wildlife, both in the Sacramento and in the Delta. And so the settlement process worked out almost all of the protests to about the amount of water and water availability. They ended up making significant changes to the way they took water out. They ended up making some deals with some very early water right holders who said that they, in certain circumstances, they would withhold. The cities could pay the older water holders to let some water go by so that there would be more water available than for this new application. And then they settled everything except for the cumulative impacts to the delta. So how many little water diversion, so the amount of their water diversion isn't one that you can probably even measure once you get down to the delta, the impact of that. But there are a lot of diversions along the Sacramento that are all by themselves of an amount you probably can't really measure by the time you get to the delta, but cumulatively, they could be measured. And so that issue went to hearing. And because it was a very narrowly defined issue, that hearing was resolved in about, I think it was about 5 months, maybe 6 months. So that's just an example of, a concrete example of how a water rights proceeding that's protested can go. Yeah.
Can I make an observation and kind of complain on that also? It's kind of just following the money, you know, like money's always going to production and development and never conservation, and it's just like you gotta follow the money. It's kind of the bigger issue when your economy is based on, you know, using the resources to profit on them, and that's, you know, another issue that, that's something that I see one, just going and walking down the backside of town and seeing like 4 hoses on, you know, that demolition, it's like, wow, you know, must be nice. You know, that's, you know, yeah, just a complaint / generalization.
Okay. Yeah.
Is there a central area where you guys notify the public about, back to
Mhm.
the previous slide, when somebody with an existing water right is going to change it, or when a new application or an old one expires and a new one's up? Is there, you know, some place where you can go and know everything that's happening throughout the state on those?
Is Jeff Wetzel still here? No. I am not exactly sure whether, I don't think that every action that we take is available on the website. We do have, you know, if you have a statement of water diversion and use filed with us, you're going to get something sent to you that gives notice of actions that potentially affect that water right. That'll be the notice list. There are also electronic email lists that you can sign up for. What are they called? LIRIS lists. LIRIS lists. And there's a LIRIS list if you want to be notified every time we get an application, if you want to be notified every time we get a permit, a change petition. There's a series of LIRIS lists, and I'm sure the ERIMS people can also sort of walk you through the website area where that is. And that, I don't know if it's all compiled somewhere, but you could on the list to get notice of every single one.
Yeah, well, that's a concern, because I'm not a diverter, so I don't have a thing, but
Right.
I am a citizen, and I'm concerned with public trust doctrine, and I'm concerned with beneficial use. And as a California citizen, I should have that information available to me that is gonna affect any type of water issue in the state somewhere, you know, and it should be a central area I can go to, find out what's going on right now, who's being applied for it, without having to try and search through a whole bunch of different lists. Do I need to sign up for this one? Do I need to sign up for that one? Do I need to sign up for that one? Like, for example, let's say that, let's say that they approve the enlargement of Shasta Dam. Bureau of Reclamation is gonna have to reapply for a new permit for the expanded, water that's gonna be in this thing. Yeah. I'm not a diverter, so I'm not gonna automatically get notified even though I'm on the McLeod. So how would I know when they're getting ready to apply? How would I know when their existing permit expires? You're gonna show me where to look at their existing permit, so I know what the conditions are of it, you know, but how can I know when a hearing's gonna be, so I can input either protest or, input what conditions I think they need to meet in order to be approved that permit. So those kind of things.
So,
Gita, do you
yeah.
want to take that at public
Sure.
participation?
So one of my hats is Director of Public Participation. We manage lists of both federally recognized and non-recognized tribes. We have email lists for your environmental directors. We have snail mail lists of tribal chairs. I try to make it a point to make sure that staff is aware when there's something of statewide significance or of tribal concern, that notification goes out to everybody, regardless of where they are. So I will make sure that I talk to water rights staff, especially for issues regarding the dams, and make sure that notification goes out when such actions are, and public comments are available.
I appreciate that, but I think just thinking that it's only an issue, a water issue that might affect the tribe over here, tribe over there, is not what I'm talking about. I'm talking about a water issue that's gonna affect anybody in the state of
Sure,
California. Because
sure.
anytime a new water right is issued, or anytime a permit is re-upped or modified, that affects water anywhere in the state because
Sure.
it's all one system.
So this afternoon, after the groups at the stations outside, we'll reconvene with a panel. Jeff Wetzel is part of our Division of Water Rights, and we'll ask him that directly. Thank you.
Okay, I'm actually going to keep moving at this point to adjudications, if that's okay. Can you hold? Okay, excellent. This is just to emphasize there's not a sovereign immunity problem with protests or complaints. At least we don't see one. Adjudications will result in a determination of water rights. So an adjudication is a decision by a court, ultimately, that looks at an entire body of water and all the different types of rights that might be on it, and makes a determination about who's allowed to use what and who's in front of whom. And we have on our website decrees from these adjudications. I have the site up there, and typically there are these very long, involved things with many, usually these schedules of like, okay, everybody on this sheet, you know, can divert at this place and use at this place for this purpose. And then it'll list like, these people can divert first, and these second, and these third, and these fourth, and then, you know, some of them go off to like fifth, or, you know, then finally you get back around after everyone's on this list and there's still leftover water, then who gets to take that we haven't even really adjudicated, and super wet years, and they can be very complex documents about one area. The McCarran Amendment, so it's a federal statute, waives tribal sovereign immunity for the purpose of adjudications. Not just tribal sovereign immunity, it waives federal sovereign immunity. So state courts can make a binding decision about federal water rights and tribal water rights in those adjudications. As a note about the McCarran Amendment, it does not waive sovereign immunity for the purposes of paying fees. So an adjudication is paid for by the people asserting water rights claims in the adjudication. However, the federal government and federally recognized tribes would not be on the hook for those fees, but at least for the state water board's purposes, whether we could pay for the adjudication would be part of a factor in whether we decide to take one on. So we'll go and we'll talk about where the decision point is for the state water board about those decisions. So I just wanted to flag the resources issues in terms of the cost of adjudications. So adjudications have a lot of very, very, very fine qualities. They can bring a kind of finality and certainty to water rights that nothing else really, that is very difficult to do otherwise. That whole thing about, oh, there's someone 300 miles away, how am I supposed to know how much water they need? Well, the adjudication It'll all be written down. They'll be like on page, 47, they'll have their, what they can do and then what you can do and what you have to do to protect them and what they have to do to protect you. It's enforceable. You can have a riparian water right, and you can have an idea that there should be natural flow going by your land right now, and that you should be able to use it, and that maybe somebody else should be not using their water right. But if you have a number that you can go in there and say, look, I don't have X, Y, and Z, that is a lot easier to enforce than these sort of much more vague senses of well, I have the right to some water, but I don't know how much, and I don't know what other people are doing. It makes it much easier to enforce. And there's a court there that's looked at it all. There's a very clear place where you go to enforce that. Often you can actually get a water master to divvy up the water. So you can actually know that somebody 200 miles away is doing what they're supposed to be doing without having to drive over there and see what their field looks like right now. And it's one of the only ways to quantify a Federal Reserve right. So if you have a claim to a Federal Reserve right, and you have one of these, one of these vague standards is going to apply, and how do I know what the purpose of the reservation is? This is how you find out. You find out in an adjudication like this. So why doesn't everybody do this? In some states, everybody does do it. Idaho and Montana and Colorado, all, if not almost all, of the water rights in those states are adjudicated. You can just go look anything up, and there it is right there, and check that off. It is very, it's a very lengthy process. You're talking about an adversarial proceeding with hundreds of people, and it takes years and years and years and years. Some states have dedicated a lot of funding to doing that. The states I just ticked off have, their legislatures have said, we think it's really, really, really important to have all of these adjudications. And we are going to, for the next 30 years, set up a water court, and we're going to pull everyone into it, and we're going to have these really clear rules about who has to pay and who doesn't have to pay, and we're going to have a lot of general fund support for it, and we're just going to make it happen. That has not happened in California. We have a very piecemeal system here in terms of adjudications. To give you an idea of timelines for these, the Klamath adjudication and the Gila River adjudication, and I've talked about both of these earlier. So the Adair decision with the Klamath tribes and the Gila River tribe decisions on quantification. They've had certain parts of that have been cleared up, but other parts of that are still ongoing. They started in the 70s. Now the Klamath adjudication just got a recommendation from the administrative agency, hasn't been entered yet into the court, a year ago. It started in 1973, I think. And the Gila River also started in the 70s. There's still no final decision issued there. So it can take a very long time and cost a lot of money outside of a sort of a system that supports the state more to specifically adjudicate. That said, it can be worthwhile. Here's an example of Bidwell Creek. There's an adjudication there, including some tribal rights. That's what one of those decrees look like. So it'll be titled in the matter of, usually it's titled in the matter of whatever water body it is. And then, the United States, that's what sometimes the tribal rights end up as. And then it says, okay, how much can you divert and where? These are different points of diversions. They'll be on a map somewhere. How much is first priority? Okay, you can take this much first priority here, and then at these other points of diversion, you can take all the flow, and then over here, you have your total. And that's what it ends up with. It's very final. And sometimes it can be worth getting to that point. Whoa. So there are two kinds of adjudications of surface waters in California. You have what are called statutory adjudications. They're at this site in the Water Code. And anyone that's claiming water can petition the board to open up an adjudication. And then the board makes a determination whether that's in the public interest for us to open up an adjudication. That's the point at which we can sort of look at the finances, we look at all of our priorities, we look at the need for finality, we balance all kinds of factors, and we say, yes, we're ready to take this 30-year plunge, or no, we're not ready to take this 30-year plunge. The process, if you follow the statutory adjudication, is that the board, does an investigation about what they think is going on in the river, how much water is available, who does it look like is diverting, and how much, and what the needs might be. And then claimants file what's called a proof of claim. So they say, okay, I divert this much. It looks kind of maybe similar to what a statement would look like. And then the board issues a report and a preliminary order. And then there will be objections, and there will be a hearing. Although technically, I suppose those are not mandatory. And then there'll be a final order of determination that gets filed in the Superior Court. The Superior Court then takes another round of objections and can either adopt what the State Water Board recommends, it can amend, it can make changes to what the Water Board recommends, or it can go adopt something radically changed. I guess it would still be changes, but a non-statutory adjudication, and that's what they're called, is one that's just filed directly in state court or in federal court. Now, often, if you file, well, I'll get to that detail in a minute. So the courts can then refer the case back to the State Water Board, which often happens. So you can try to do some forum shopping if you don't think the State Water Board is going to be, give you the answer you're looking for. But there's a big chance it would end up in front of us anyway. And then the court and the State Water Board are applying the same body of law. So all that stuff we were talking about, what are the different water rights, and when do you lose them, and how much can you change them, and how much can they be for, and how do we quantify it? All of that law is supposed to be the same, no matter whether it's the State Water Board applying it or no matter whether it's the courts applying it. So all of that, regardless of whether you do statutory or non-statutory, all of that is going to remain the same. Just a note about filing in federal court, if the state is claiming any water, then the state's sovereign immunity can be an issue in filing in federal court. And then obviously, if you're a federally recognized tribe, there can be sovereign immunity issues with filing directly in a state court. So the sovereign immunity issues are ones that are going to come up in an adjudication context, because you are deciding which area is going to make a final decision, which federal or state authority is going to make a final decision about state water rights and about federal water rights. And this isn't our procedure, but I'm just mentioning it because it can end up with us, and because it's relevant to sort of a complete picture of what different options are. Similarly, this is not one of our procedures. Wait. Individual lawsuits also aren't one of our procedures. This is a little bit analogous to a complaint procedure. So if somebody is illegally diverting or is diverting in a way that negatively impacts you, you can file a complaint with us. You can also take them directly to court. So you can file in federal court or in state court. Often what will happen, this isn't necessarily the case, but one of the things to be aware of that can happen if people you file an individual lawsuit, against one diverter, they might well say, well, there's no way to tell if the problem you're having is because of me, unless we adjudicate every single right in this basin. So depending on how complex everything is, this can easily spiral out into an entire adjudication. So there's a chance that that you can deal with just a smaller piece of the pie. And if you're in somewhere where you have one really big diverter that's clearly causing the problem, and you can try to go at things more narrowly, but there are no guarantees. It can spiral into an adjudication and a whole different level of commitment. And then, like an adjudication, it can be referred to the State Water Board, and the State Water Board and the court would be applying the same bodies of law. And the risk of it spiraling into adjudication. If you're suing the person who's most junior, then there's less of a risk of that. So if you're suing the last person in line, it's much harder for them to draw in other people and say, oh, no, it's really this other person's fault. But if you're suing somebody and they have a 1910 right and there are 40 other people that have different water rights later, the chances of being able to deal with just the one without bringing in the other 40 at least, and probably the whole, basin are slim. So all of this helps explain why very often in California, rather than go through administrative processes or go through court processes, people tend to enter into cooperative agreements. I don't think Doug Garcia from BIA was able to be here today, but he's expressed, several times that it's their policy not to, it's their policy to try to enter into these cooperative agreements, that they've decided they basically don't want to take on the adversarial approach. That said, often cooperation can be encouraged by the threat of some type of non-cooperative legal action. And so very often, and this was the case in the Yuba slide I had up, there we were in a very adversarial process. There were environmentalists, there were wildlife agencies, there were a range of different diverters, and everybody sued us. Nobody liked our decision. We were getting, sued by people who said there's not enough water for fish, and then we're getting sued by people who said you're taking too much water out of our agricultural water rights. And that could have, continued, and we could have gotten resolution that way. But what people decided, even at that late point, was that what would work best would be to get together and find how can we really make this work best for everybody. So very often, this is where water rights end up. So the next section of the talk, when's our next break? Oh, not till 3, okay. Yes, okay, we have protecting in-stream flows and groundwater. So I think what would be helpful is to skip my next slide, which says questions, and and to go through the protecting in-stream flows part, because it's very closely related to what I just talked about, and then have a question section, and then kind of poor groundwater. It's always the stepchild. Take that one a little bit later. How many people are not going to be able to go to the EPA summit to get the groundwater there? Okay, a number of folks. Okay. If it comes down to it, I can meet with you all afterwards to discuss more about the groundwater if we, okay. Interested in groundwater? Yes, yes, okay. All right, so in-stream flows. No one saw that. Protecting in-stream flows, we're gonna talk about 3 different ways to protect in-stream flows. The first one is gonna be in-stream water rights. The second one is gonna be the public trust doctrine. And the third is gonna be the reasonable use doctrine. So in-stream water rights. So every single thing we just talked about protecting and asserting a water right, holds true if you have an in-stream water right or if you have a claim for an in-stream water right. So the complaints, the protests, the adjudications, the individual lawsuits, all of those methods are gonna look exactly the same. You're just gonna say, you're not impacting my ability to divert. You're gonna say, you're impacting my in-stream water right. Now, what kind of water rights can be an in-stream water right? Pardon? Potentially riparians. So there's a split on the riparians. There's an argument to be made. And, pardon? Yeah, the fishing rights, that's an example of an in-stream water right. If we're talking about riparian, appropriative, and Federal Reserved rights, which one can be in the river and which one can't? Federal Reserve can, and the appropriative cannot. Except if you file one of these petitions. So there was a case that came out that it was unclear whether you could have an appropriative in-stream water right in California. There was a case came out that said you absolutely cannot. Part of appropriating water is taking it out of a stream. That is not what they found in Oregon, for example, but that's how it ended up in California. Very soon after that case came out, the legislature passed a statute that said that if you have a water right, and it doesn't matter what kind of water right, you can petition the board to change that to an in-stream water right. This is called a 1707 petition. So you can use that for wetlands habitat, fish and wildlife, recreation, things like that. It doesn't even actually have to be in-stream, but you know, typically it is. So if you have, for example, or one of your neighbors has a water right that they've been using for irrigation, it's pretty substantial, you can change that water right without losing it. You can say, I'm gonna leave this water in the stream, and that's gonna be how I use it. Or you can coordinate with neighbors to reach agreements for them to do that without having their water right be at risk. Does that make sense?
So you're not gonna use it for farming, you're gonna use it for habitat. So you're not gonna lose it by not farming. So you always maintain it. You just have to proper avenue to keep it in the creek.
Exactly. So if you just keep it in the creek and don't do anything with it, and it's an appropriative water right, you lose it after 5 years. Or you keep it in the creek and you're not using it, someone else can use it. The next person in line can just use it. But if you get one of these 17, so the next person in line being the next person junior to you, can say, hey, look, here's this water. You weren't using it. It's not like your car, right? You're not using it. Someone else can go drive it. So this says, hey, I'm using this. I'm using it right here in this creek. You can't have it because I'm using, this is my water right, and I want it to be right here. I want it to be right here in this creek, and that's what I'm doing with it. Yes? It will remain actually as an appropriative water right, and I'll go over that on the next slide. So you're filing with us to change a water right. So the State Water Board is going to apply a no injury rule. It's difficult to imagine how leaving water in the stream and not diverting it, how someone else is going to be legally injured by that. But nonetheless, you have to comply with that. And we have had, people come in and say, I want to be sure that, we've had people come in with, claims about runoff or claims about groundwater recharge, and we work through those things. You can't increase the amount of your right. So if you were just going to be diverting, you have your water right and it says 5 CFS and it has this season, but actually you would have diverted some to your fields and then done nothing for 2 weeks, and then diverted it to your fields again, and then done nothing for 2 weeks, and then diverted it to your fields again, because that's actually what crops need. These theoretical crops that I'm making up need. Then you can't say, oh, this in-stream right's going to be for more than I actually would have used. So this is kind of about the measure of the right. The measure of your right is what you actually would have used. It can be conditioned in the public's interest. So if there's some kind of limit to the change that would be necessary to protect the public interest. Again, it's a little hard to think what those might be when the change is just not diverting water and leaving it there. But nonetheless, this is the rule that the analysis that we'll do. And then it can be permissive. So this is the question I think you were raising. You can apply for this right to say, I would like to have the ability to leave this water in stream in very dry years, but I would actually like to continue irrigating in wetter years when the fish need the water less, because I want to continue to produce on this, on this land. And a lot of people, a lot of water trusts will set situations like that up with water diverters that face particular challenges only in certain water years. So that's something you can do. You can also request us to make the change mandatory. You can request us to take off irrigation use from your water right. We're not going to go and take it off just because it's in front of us. That's not a change that we have the authority to just go ahead and make without your permission. But that's how these can go. As far as I know, these have never been used for unexercised riparian rights. And I think you would have a hard time showing the no increase in the right requirement if you were talking about an unexercised riparian right.
Can you address the curtailment at this point?
I'm not
Of the state just directing all, like, for Pitt River area, for Pitt River tribes, that we cover 4 counties,
mm-hmm.
huge watershed. Everything's going down from our federal lands to, I mean, basically what happens, bottom line, is we don't have a voting population in California from Sacramento up to protect and preserve our water rights like we should be able to protect and preserve our water rights, rights for fish and wildlife and for everything else. So we get outvoted all the time. Huge money drives this. Huge money drives this. So how does the state get to curtail?
Let me pull that to the end of this discussion, because I think that's one of those larger issues that I was thinking we would discuss maybe after we talk about these different hooks. So in terms of protecting in-stream flows. And
And if tribes can bring consultation into this process, other than legal and stewardship grants, where we can actually bring consultation and our solutions to the state level of what we want, rather than just waiting for the state to figure out what they're gonna do next. Because it's never been good for tribes.
okay. I think it makes sense that's not really the focus of this, is kind of laying out this toolbox. And your question goes to what's the larger context that we could use these tools in, right? And so right. So if it's a winner's doctrine right, yes. Let's talk about this question a little bit later, because I think it's very specific to the Pitt River tribe. So it seems like there are two issues that are being brought up. From a water rights perspective, I see two issues. One would be what happens to the water and how do you protect it where it is, which is what this part of the presentation is going to get into, some of the ways to do that. So one way to do it is to take water that's been taken out, file a petition, and have that be a water right to leave the water back in. That's kind of where we are. The other issue I think you're bringing up, and I'm not entirely sure, is why did the State Water Board issue a curtailment in the upper watershed of the Sacramento, right? I feel like that issue is rather different than the issue of how to protect water in stream. Because it's saying where's the authority over taking water out? And the in-stream is about not taking the water out.
And I thought I heard her say something about consultation. Why was there no consultation with the tribe from the state? Am I correct with that?
We meet with the Tribal Advisory Committee with Cali PA, and we're in the process of figuring out how we define consultation, how we do this. It's new to us. We are working on a policy, a Cali PA policy. It hasn't been finalized yet. We're in the process of it. The Tribal Advisory Committee met last week and provided us with some draft language. And so we're still trying to figure that part out. In this extreme drought, there have been, as Felicia had mentioned earlier, there are monthly consultation calls with tribes the last week of every month. The curtailments were discussed. You know, I think we're still trying to figure out how to do this, and it gets into bigger issues. And we don't have a consultation policy yet, but we're working on it. It's not a great answer, but it's the current answer. And as we figure out how to do that, I know that we met with the Pitt River. I mean, there were a number of months ago, there was a consultation where a bunch of folks came up there on some very specific issues. And so we're figuring it out. We're trying our best, but we haven't gone there yet. And it is something that in the future, I imagine, once we have defined how we do consultation, we will do that. Sure. And we have a common interest. Our mission is to protect the beneficial uses of the state. We have a common goal. We want to make our waters fishable, swimmable. We want you to be able to engage in cultural resources. I mean, we have all of this in common, and we're making baby steps, but with the beneficial use issue, it's something we recognize should be considered statewide. It's going to be in our toolbox. We're working on consulting with folks to get the right language. But as I said, we have a long way to go, but we're getting there. Okay. Understood. Okay.
The comment I want to make here is that, since 2009, we've been requesting some engagement on these issues, and nothing has been done so far. We had the Dummy Committee last year on the tribal water planning, which did nothing really to change any of this, while our water rights are being overrun. And at this point in time, the president has signed UNDRIP, and we should be requesting consent on these projects and divert water off of our fish and everything else that we have. We need not just consultation anymore. That's old. We should want consent on these projects that affect Native peoples and Native environments. That's what we need to work on. And the law, in the meantime, is passing us by. We're waiting for states and federal governments to come up with some sort of laws for us, and probably we should be filing lawsuits, class action lawsuits against the state for these curtailments and for the diversion plans emptying our rivers. 200 CSS from a 1,000 CSS river is a harm, which continues to go on because PG&E wants it. So we need new laws, and we need the state to get rid of those excuses. Those same excuses was before we had all these tribal liaisons in all of these departments. Now the tribal liaisons tell us the same thing, and we've got nothing still to address these issues. Okay, that's it. I'm done.
So the content of that lawsuit you're considering filing, I'm going to pull it back here.
You're putting Mariana on the hot seat. So some of the water rights questions, curtailments, things like that. Jeff Wetzel is back in the room. He's going to be on the panel. So after the poster session outside, we'll resume back in the room, and you can pose some of those water rights specific questions to him, especially about curtailments and things like that. Right? There we go. So if you wouldn't mind, let's barrel on through.
Yep.
And we'll get there sooner.
Commencing to barrel. So about that water lawsuit that you might file, hopefully not against the state, but you might want to bring up the public trust doctrine. So the public trust doctrine is a legal interest that the states have in tidal and navigable freshwaters. So it's not to every single piece of water. But then in California, we also have it to fish in any water. I added that. For the benefit of the public. If it's still a navigable water, it doesn't depend on the fish. If you're talking about depending on the fish, the question of fish once having been and now being gone is unanswered. So there are a lot of strains of this public trust doctrine that basically go back to Roman law, and we go back to way ancient European history where you had the Romans and they were taking over all of Europe, and eventually that part of Europe became England, and then England moved over here, and then that sort of roots of common law, that's how this doctrine came up in California. So there are a lot of things that a lot of people have said about the public trust doctrine, and it's the nature of a doctrine like this that a lot of those things are still going to be relevant today. So the state is the trustee for the public trust, and it can't abdicate a responsibility to protect the public trust. So what in the world does that mean in the context of water rights? It means that the state can't grant legally a water right that hasn't balanced these public trust needs. Now, it doesn't mean that it needs an absolute protection. The state can look at that and say, you know what? That is a very beneficial fishery, and this will be a really, really beneficial city, and we're picking the city. The state can do that, but the state can't ignore the question. And to the extent that a decision has been made that does not take the in-stream uses into account, the in-stream uses of the navigable waterways or the needs of fish into account, you can undo things as if they had never been done, because there wasn't the right, nobody developed a right to do things in a way that harms the public trust. It's a very odd sort of hindsight looking articulation of this doctrine. It says, okay, you have this piece of paper that says you have this and this and this and this and this right, but actually that's not correct, because the state didn't have the right to grant all that. So we're going to backpedal out of some of that diversion right and limit it. So this is something that the public trust doctrine can do. So here we have Mono Lake. That beautiful lake is the place where the litigation happened in 1983 that clarified to everyone that this doctrine that's been around since Roman times applies to diversions of water in California. So we had all of, the BCs until 1983, and nobody was applying this doctrine, which the court then announced and said, by the way, this is what should have been happening this entire time. So this case concerned the city of Los Angeles' right to divert water from tributaries to Mono Lake on the east side of the Sierras. LA had water right permits from, I believe it was the predecessor to the State Water Board. And it said, oh, you have a very long time to develop these water rights, but as LA grows, you can get more and more water. And so they built, one set of infrastructure to pull water down there, and then they needed more because LA grew. And then, so they built a second water system to pull more water down out of these tributaries and take it to LA. The water level then in Mono Lake, at that time it was above these tufas. And it became so low that it connected islands within the lake where huge numbers of gulls would travel to do their nesting. It connected these islands to the land, and the predators could get to the birds, which is why this case is called National Audubon Society. So the Audubon Society said, you can't give away the water that these birds need. You can't give away so much water that the nesting ground, that the rookery for the biggest seagull rookery in the West is decimated. You didn't have that right, state of California. And so they won. And they said, LA, even though you're LA, and even though you need the water, and even though you have a piece of paper that says you can take that much water, and you just spent a lot of money to build some pipes to take more water, you can't have it because it is needed in Mono Lake. So that's a pretty game-changing statement. So this is a very strong doctrine. California is one of 2 states that applies the public trust doctrine this way. Hawaii is the other. It's relatively recent, sort of in, I guess, any kind of history, no matter how you look at it. You know, it's a 1983 decision. So basically, this is where we've ended up. In California, you can only develop water to the extent that outweighs the public's interest in having that water remain in the stream. And so every diversion has to be weighed against these public trust values. It's an inherent right on any water right that has been issued even in the past. It's an inherent limit on water rights that have never been issued because they aren't the kind of water rights that need to be issued. And it's an inherent uncertainty in water rights. So, you know, there's sort of 2 sides of the coin. It means it's not a self-executing doctrine. What is this going to mean in any one case is something that is going to be heavily contested. So this is an example of the types of in-stream values or public trust values that there have been court cases that address. And then on the other side, you have, you know, benefits of diversion. And so you have to look at, okay, there's this particular industrial use. What do we think that that is going to do to recreation? What do we think it's going to do to the fishery? What do we think it's going to do to science? What do we think it's going to do to navigation? There are all these things that you balance any diversion of water from a navigable stream out of, or affecting a navigable stream, excuse me. The indigenous things are not on there because there has not been a case about them specifically. So this is a list drawn from cases. I mean, fishing can be an indigenous thing, and that's on there. You know, navigation certainly can too, and this is on there. But in terms of, you know, water available for cultural uses, things like that, there hasn't been a case. So the source I'm drawing this list from doesn't have it. Yes?
So does the public trust doctrine only become
The-
enacted, applied when there's a court case? Or does the State Water Resources Control Board actually review water rights with that in mind? Not just new ones, but old ones. How do we make this happen without court cases?
Good question. I'm gonna get to that. So just a little bit more about the public trust doctrine. It applies to activities. So it's about navigable waters and fish in California. it can apply to non-navigable tributaries to navigable waters. So when you're thinking about, is this even something that's going to apply to my area? Is there a fish in it? Probably going to apply. Does your fish have to actually be a fish? No. It can be the definition of fish in the Fish and Game Code, which includes some other things like crawdads and clams and stuff. And does your water actually have to be navigable? No, it just has to affect a navigable water. There's a new case up in Scott River clarifying what has always been the State Water Board's position, that it doesn't even have to be a non-navigable surface tributary. It can also be groundwater that's tributary to a navigable water or water that has fish in it. The public trust, just to go over again, it's not absolute, it's a balancing. So even though it has the word trust, and sometimes in the law, trust means this goes over everything else and this is your duty in front of everything else. That's not what this public trust means. That's not the development of this law, hasn't been in-stream use trumps everything. It's in-stream use has to be taken into account, and you have to make a good effort to, to protect it. You can't just look at it and say, who really cares about the fish? You have to care about the fish, but you can decide that something else is more important. So we can, this is another way of saying that we can approve appropriations despite foreseeable harm, but when we get an application in front of us, when we get a change petition in front of us, we have to consider that. So the actions that we undertake, we have to consider the public trust. It's subject to the reasonableness doctrine, which is what we're going to get into next. And the state has, it's what's called a duty of continuing supervision, which means that the state should look at existing diversions and say, okay, where do these comply with the public trust? And we can reevaluate decisions that were made earlier, or decisions even that we didn't make. So this is, we're getting into our authority. I think you'd ask this question, what's our authority outside of pre-1914 appropriative rights? This is one of the few areas where we do have authority over diversions that aren't post-1914 appropriative rights. So we have this duty of continuing supervision. Now we're going to get really technical and really lawyerly and tell you that that is not a mandatory duty. So the fact that there's this duty out there doesn't mean that every time this hasn't been balanced, we're supposed to have already done that already. The law recognizes the finite resources that have been made available, and the State Water Board has the ability to prioritize things. But as things come before us, and as we do make decisions, we do have the obligation to take these things into account. So we have the obligation, we have the duty to take them into account. We don't have to go back and look at every decision that was made before 1983, made by us and made by other people, and reevaluate it. We have the authority to do that. And then, because this is just kind of an undergirding limit on all water rights, the public trust doctrine doesn't raise a takings issue. So very often, if you have a water right, if you have your car, and I look at your car and I say, you know what? That car is emitting a lot of carbon emissions, and I'm going to take it back because we'll all do better if that car is not on the road. We're just going to put that in the garage and leave it there. I would owe you the money for that car. The state would owe you that money because that's not an inherent limitation of your ability to drive a vehicle. But with the water right, this public trust limitation is an inherent limit on that water right. And so the takings issue, although it is oft claimed, it is our position that it is irrelevant in this context. Here is a statutory definition of the public, of one strand of public trust that comes up a lot. This came up actually in the Mono Lake case. Fish and Game Code section 5937 says whenever you have a dam, you're obligated to release enough water below that dam to maintain the fish that are there in good condition. So that's just a statutory expression of the public trust that comes up a lot when you're looking at in-stream water right issues. Now, the larger question, so I think we talked about how the state water board, every time a decision comes before us, it's an obligation to look at the public trust issues. The ways that you can raise these issues to the state water board and say, hey, you really need to be reevaluating this one, is the processes that I went over already. So the complaint process, if there's something already ongoing and it's in violation of, you feel it's in violation of the public trust, you can raise that in a complaint. The protest process, as we're, looking at an application for water rights, you can intervene and say what they're proposing is going to have X, Y, and Z harm, and that's not okay. That's too much for the benefit that's going to get gained here by, the proposed water right action. You can also go straight to court. You can sue in state court or in federal court. And if you have an adjudication already existing, it is likely that if you claim on behalf of the public trust that you can go in and reopen that adjudication, that would give you the standing to do that. Okay. I think, so any more questions on the public trust? I know I said no more questions, but this is like the big one.
Hang on. Those on the web can't hear you unless you're on a microphone.
Oh, so the web is working now?
The web was working, yes.
Well, I'm glad you put Mono Lake up there as an example, but I have a good question for you too on something that's getting ready to come up, and how the public trust reasonable use, which we haven't talked about yet, doctrine, and State Water Board's decision, and who's going to get the water permit for what's about to take place. If Proposition 1 passes, Sites Dam is most likely to be constructed. It's their top priority under the $2.7 billion on there. That's an off-stream dam. There's no water flowing into it. The water that has to go into that dam has to be siphoned off of the Sacramento River, and eventually the water that's brought over from the Klamath and Trinity River back down into the Sites Dam. Who's going to own the water rights? Who gets the permit for that? And since we already have a problem of endangered species on the Klamath and Trinity and on the Sacramento River as far as our fisheries are concerned, how will the State Water Board look at that and justify authorizing a permit and a use permit and a water right for that particular dam, which is off-stream in the first place?
So that's a bundle of questions about the Sites Reservoir, the proposed Sites, excuse me, reservoir. This is really embarrassing, but I can't remember who's proposing the Sites Reservoir. But that, presumably the person proposing it would be the one getting the water right. There are lots of murmurs. Clearly people here know who that is. You mentioned the Bureau. It could be them. I don't know. It could be local. I don't know. It could be DWR. They often do a lot of water planning for the state. So the public trust and the reasonable use doctrines will be taken into account in any decision the State Water Board makes on those reservoirs. If you like, we can talk more about, why don't I go through reasonable use, and then we'll talk more about how these things work. Although I'm not sure, without delving into specifics that I don't know about Sites Reservoir, that I can really say a lot about how they would be applied, except that, you know, if they're endangered species, you know, if it's not on the stream, then the impacts to that stream are going to be different than if it's on the stream. And that it's the effect, to the extent that the additional water has an impact on listed species or on not listed species, that is something that will, you know, be taken into account and potentially
Basic premises, sites
be
have
mitigated.
no inflow of water. The site's location will have no inflow of water whatsoever. It's a barren area that they're gonna dig a hole in the ground and put some cement up, and so the water has to come from somewhere. The water that's going to come into there will come from Trinity, Klamath, Sacramento River water, which is already over-allocated on those. Knowing that, and knowing that we have fisheries that are endangered on the Trinity and Klamath, and fisheries that are already endangered on the Sacramento River, the public trust and the reasonable use and all that good stuff has, do you anticipate the Water Resources Control Board taking those doctrines into account and allowing that thing to be built in the first place, or allocating permits or a water right for the water that'll be stored there in the first place based on those doctrines, you know, on the public trust?
My guess is that that will be a very hotly contested issue, and that will be one of those issues that is brought up in the protest process when there's an application in front of us, and that would be resolved through negotiation or would be resolved through a hearing ultimately, is my guess how that will be handled. So I'm going to jump now to the reasonable use doctrine. This is in the California Constitution, Article 10, Section 2. This became part of the California Constitution by referendum in 1928. In 1928, it was just after a California Supreme Court decision called Herminghouse v. Southern California Edison. And in that decision, Southern California Edison had applied to build a water storage facility, and the California Supreme Court said, you know what, you can't, because there's a riparian downstream, and often that floodwaters that you're storing will flood the fields and irrigate them that way, and she likes to have the irrigated pasture. She depends on that. That's how she irrigates. And the California Supreme Court said, well, that's not really reasonable to say that you can't have a storage facility and you can't have hydroelectric energy and you can't have, you know, municipal use, and you can only use this water, to a whole lot of water, to irrigate a field a few times in winter. But reasonableness doesn't apply to riparian rights. You don't have to be reasonable. And so, Mrs. Herminghouse, you win. Please continue flood irrigating your field. 1928, there was a referendum, and the California Constitution was amended to say you can only use water reasonably within California. You can't waste it, and you have to divert it in a way that's reasonable. You have to look at the larger context of water use. and determining whether a certain diversion is going to be considered reasonable. It's typically a case-by-case analysis. How does this play out in the real world? A case-by-case analysis. And so you look at all the uses, you know, for the water that you know about, because someone's filed their statement of water diversion and use. And you look at what the water is being used for. And then you look at kind of the larger context of the state's water needs. Is this an area that's has excess water? There are areas of the state that's maybe not this year, but in general tend to have water that's not being used by anyone else. Is this one of those areas, or are we talking about, you know, the San Joaquin where all of it's being used more than once? And then reasonableness, you also look at, you know, with Mrs. Herminghaus, for example, they're not saying she doesn't get any water right. They're just saying you might have to install a canal, Mrs. Herminghaus, and so that you can irrigate your field using about, you know, 1/10 of the water that you could have used, so someone else can use the water and you won't be harmed. So you look at, you know, how hard is it to change around what's already going on? What's the technology even? And who should pay for that? You know, if somebody is doing something and they're going to have to change, if what they're doing in this context isn't reasonable, well, who pays for that? Is it the newcomer that pays, or is it the existing user that pays? So I'm going to go over a couple of examples of how the reasonable use doctrine has been applied, because I think we all understand that there's the word reasonable, and that reasonable people might differ a lot about what exactly that means. So I'm going to go through some examples about what the courts have said, where, you know, the reasonable use doctrine, you know, things are so out of hand that the unreasonable use doctrine applies. So the case where this was tested, first of all, well, that's a beautiful picture. That's Nicasio Creek up there. And that is the setting of Joslyn v. Marin Municipal Water District, which is a principal case, a California Supreme Court case. So Marin Municipal, this is actually very, very similar to the facts of the Herminghaus case. Marin Municipal built a dam for municipal use upstream of somebody that had a sand and gravel business. Well, obviously the dam is going to block the sediment. And the person's sand and gravel business is going to go downhill very fast. And this is what the court said. Is it reasonable, then, that the riches of our streams, which we are charged with conserving in the great public interest, are to be dissipated in the amassing of mere sand and gravel, for which ought there appears to subserve no public policy? So if you can frame your question like that, then you have a reasonable use case. You can tell just from the answer to that is no, obviously. The California Supreme Court did not think it was reasonable to have sand and gravel business instead of water for a municipality. So we're going to move on past the creek. This is a much more recent case. This is a 2014 case. The State Water Board has twice issued a set of regulations, one in Napa and one along the Russian, that regulates the use of water for frost protection of vineyards. So typically, you know, your typical agricultural irrigation season is going to be in the summer, because that's when things are dry and that's when things are growing very fast. But grape growers, there's a certain point in the spring when the grapes, I can't remember if it's the grapes or the leaves, but a certain point the grapevines are very vulnerable to frost. And if you get a cold enough chill, then it can make a huge impact in the productivity of that year's grapes. And so what happens, particularly as grape production has expanded greatly in the Napa and Russian River areas, is that everybody all at once pumps water into their fields, because the water, if you can get it onto the vines, it'll protect the vines from the colder air temperature. The water will actually freeze on there, but be warmer than the temperature of the air. Exactly. So the state water board, so a problem that people ran into is that streams were being completely dewatered on these very, very cold nights, just all of a sudden. And so the state water board has twice passed a set of regulations that says you can't just do that. You can't just pump the entire stream dry. So for this most recent set of regulations on the Russian, we said you have to coordinate with your neighbors, and you guys can, everybody can get together and pool, and you can build storage, or you can say, I'm gonna, pull water in on this day, and you're gonna do it on this day, and we're gonna have, monitoring, and we're gonna be sure that there's still water in the creek, even when it's very cold. And if you aren't part of one of these groups, then just pulling water out of that river for frost protection is unreasonable. That is not a reasonable way to protect your plants. That is an unreasonable use, and you don't have the right to do it. So that was upheld. So the court definitively said it is possible to issue a regulation about what's a reasonable use. You don't have to do it this individual case-by-case, go-to-court basis. I think that was also one of the questions. The State Water Board can issue a broader regulation, but that in that regulatory process, you do have to take the individual situation into account. Not necessarily the individual situation of the individual diverter, but you have to really look carefully at the whole watershed, and be able to balance these uses. And then you can make a broader statement about what's reasonable use and what's not. And there is frost protection in Napa on the grapes. So that's another signpost. So we have this signpost. Is somebody doing something where you have absolutely no public policy for a bunch of sand and gravel? Okay, we can say that's unreasonable if what you're measuring up against is a city. So we have that signpost. We have this signpost that says, if there's a way to protect your grapes by coordinating with people and measuring, and you don't do that, it's unreasonable to just drain these tributaries dry and kill all the fish in them. And then here's another signpost. This is State Water Board Decision 1600 with the Imperial Irrigation District. Now, IID, at the point that this decision was issued, was diverting about 20% of all the water that was being diverted in the entire state. So this is Southern California, agricultural lands, very, very, very old water rights. The losses they had, so very, very old water rights, very, very, very old infrastructure to go with the very, very old water rights. They had very, very leaky canals. They had overwatering problems, and the canals would spill, which is to a large extent a maintenance issue. And so 40% of that water that they were diverting into the canals was being lost. Wasn't even on the fields, or it wasn't possible for the crops to use it. So the State Water Board opened up a hearing on their water use and found that the use was unreasonable, and the courts upheld that determination. So there's another sort of like, okay, what's reasonable? Diverting 20% of the state's water and then losing 40% of it, that's not reasonable. And the complaints were actually based on a landowner whose land was being flooded by the Salton Sea where all this water overflow was ending up. So that decision was the result of a reasonable use complaint. So similarly to the public trust doctrine, you don't actually develop the right to use the water in an unreasonable manner. So even if you had a water right and it was perfectly reasonable 50 years ago, it doesn't mean it's reasonable now. And it's not a taking to use the reasonable use doctrine. Although this is the State Water Board's opinion, we feel pretty strongly that we're right about that. There are people who disagree with that position very strongly. They have not yet won, so we continue to hold that position. And we don't think they will. Again, the state and the courts have concurrent jurisdiction. You can come to us with your complaint. We can open up a hearing about it, or you can go to court. You can sue. You can say what you're doing with water is unreasonable, and the court can make that decision in the first instance. And just to emphasize, what's reasonable can change over time. So we're in a drought this year, and we issued regulations declaring certain water use to be not reasonable during this drought. And so that's context specific. That's going to be totally open for debate again at the end of this year, or at the end of 270 days from when the regulation passed, or hopefully the drought's going to end by then and nothing will get extended. So how do you raise these reasonableness issues? You can raise it in a complaint like IAD. You can protest if someone's coming before us and you feel like the change or the application is for something that would be unreasonable, have an unreasonable effect. You can protest that. You can sue in state or in federal court. And there's no specific case law on what you do in adjudication. So the idea, in the public trust, I said there's a good chance that it will be considered that you have standing to reopen that if you're asserting protection of the public trust. There's just sort of no reason to think one way or the other on the reasonable use doctrine. It's unclear. So it is now 3:10. I am 10 minutes after where I was supposed to have been after an additional 10 pages of slides about groundwater. We have 5 minutes until the poster boards are going to be there. I was really hoping to have a little more time for discussion at the end here. We did end up taking a lot of time for discussion in the middle again. So I would recommend that folks who are interested in groundwater, that we can come up and I can go through these slides. I'm happy to talk with a microphone or without. And then the larger discussion may also have to be a little more fragmented.
So if you're still around, Mariana, maybe what we can have you do is be part of the panel from 4:15 to 4:45. And while we've got water rights, drought management, operator cert, and then I'll be talking briefly on cultural and subsistence fishing. Maybe if there are some other burning questions, we can cover them then. Maybe. Okay.
Sorry,
You have to go.
this is too much information. My mom's in town.
Yes. No, understood.
I have to catch a train and go see her.
That's right. That's right. I forgot about that. Okay. Well, maybe if there are a couple of really key questions for the next 2 minutes. Sure. Hang on.
I had a question about groundwater with public trust and reasonable use. There's not much regulation with it right now, especially between, say, a city and a tribe. is there going to be any future development from the water board to deal with that? Because currently you can only do federal court process because it is federally rights for water for many tribes, especially groundwater in Southern California. And so, how do you guys define who the public is?
For purposes of the public trust doctrine.
Right.
So quickly about the public trust doctrine and groundwater. The public trust doctrine is there protecting surface water. So except for your underground fish, like in the desert pupfish, and that was actually, the Supreme Court said that was surface water even though it was under the ground. Are you thinking about issues like subsidence, or are you thinking about the interaction of groundwater and surface water?
I'm talking about the interaction between surface water and groundwater.
Okay.
Sometimes they tap into surface water that recharges aquifers, and a lot of tribes depend on aquifers, and their overuse might actually affect tribes' groundwater levels and groundwater quality.
Okay, so the groundwater itself is not going to be protected by the public trust doctrine. The reasonable use doctrine is going to apply. And there is fascinating interactions between groundwater and surface water and how those interact that I don't feel like I could adequately address without kind of going through this groundwater stuff. But I would really like to be able to go through that, because I know people from Southern California are going to be very focused on these issues. Can you stay? Okay, excellent.
You raised a question about subsidence and on reasonable use with groundwater. Subsidence, particularly in the Central Valley, had the drop of 33 feet. And it's starting to affect the infrastructure. The aqueducts are starting to crack. What is the issue long-term of controlling the pumping of groundwater that's reasonable, that doesn't damage or injure the infrastructure and the flow of water north to south, and et cetera?
So groundwater, I mean, the groundwater regulation structure makes the surface water regulation look really comprehensive and effective. So recently, I think about a month ago, legislation was passed to, for the first time, require some kind of planning and an implementation of sustainable groundwater use. And I'm going to be talking about that at the Cali PA conference. There is not a lot of law out there, as far as I know, about reasonable use and subsidence. I think generally, if you're using so much water that the ground is falling, that's certainly something you're going to be looking at in terms of whether that's reasonable. I think that's, I don't think you can say that's per se unreasonable, because I don't think there's been a case out there that says that, and that would be what would let you say that. But, that's something you would take into account in a reasonableness analysis is, is the ground collapsing? Is it destroying infrastructure across the state? That would go into to the equation. And so just really briefly on that, there's local control over groundwater. Not many local areas have exercised that control. The recent groundwater legislation gives a state backstop. So it gives deadlines, it makes it a mandatory undertaking, and then if the local agencies choose not to meet certain deadlines to do groundwater planning, if their plans don't meet certain standards that have not yet quite been defined, then there's a state backstop and the state will come in and do the planning. So that's kind of what's to come, in very brief detail. And there's, I put in the packet a list of important dates for, basically I was trying to think of places that tribes might want to get involved in the process, and the deadlines that would be important around that. So,
Before we go to the next question, I'm right here. Speaking of the packet, if I do lose people, I want to make sure that you see in your packet there's a training evaluation. Please fill that out before you leave. But I hope you don't leave. There is a panel after the interactive stations outside, reconvening back in here at 4:15. And we'll be talking about drought management, operator cert, and the beneficial use issues. And then following that, there is a reception in the lobby over here, and I made homemade salted caramel macaron. So if that doesn't bring you back, I don't know what will. And there's other treats as well.
Thank you. During lunchtime, I was talking with Jeff about, you know, the issue of Shasta Dam again. And he said that any reevaluation of a water rights permit for the dam would trigger a SWRCB process. And so can you talk about what that SWRCB process means and how the Water Board uses the conclusions of the SWRCB process, you know, to make their determination? Is the SWRCB process, does that result in some kind of binding decision? And then, of course, you know, we have what is the AB 52 or AB 56 looming in front of us, where non-federally recognized state tribes might be shut out of the whole SWRCB process. So does that mean non-federally recognized tribes would be shut out of any of these water rights determinations and hearings?
We have
You
Mr. Sequeger.
are lucky that you asked the question at this particular moment, because Ken Bogdan from our office is a SWRCB guru. I think about half that question is water rights and about half of it is SWRCB. So I don't know if you want to tackle the SWRCB part. And
Sure. Well, I'll do the SWRCB part first. So with it's Shasta dam raise is what you're specifically asking about. And so the first question might be who the lead agency would be for that action. I know it's a Bureau facility, but I don't know if they would do that in conjunction with Department of Water Resources. There would probably be another agency, a state agency, that would be the lead agency. And we'd be what's considered a responsible agency. So for CEQA, the California Environmental Quality Act, applies to all public agency discretionary decisions. They have to do an environmental analysis before they approve a project. So let's say it's DWR, and I don't know this, would be having some coordinated operations with the state water project, so they would be somehow the lead agency from CEQA. They would do most likely an environmental impact report because the anticipated potential significant impacts. And then they'd give the draft, they'd give us a notice first asking for input, the water board input, and then they'd give us the draft and ask us for comments on it to make sure that we covered, or they covered our issues. So that's an important part of the CEQA process as well. And then we're required, after the lead agency would finalize the document, we're required to use that in conjunction with our process to make a decision. So if we don't think it sufficiently addressed public trust, for instance, well, there's a CEQA issue, which would be the environmental impacts. But then we could say, well, we don't think this went far enough for water board process stuff. So we're going to either require more analysis related to those water board specific process issues like public trust, and we'd use that document in conjunction with other information in our decision-making process. And then you ask about AB 52, which is the new law signed by the Governor Brown a couple weeks ago. And that adds an additional process for consultation. And it's not just federally recognized tribes. There's a new concept, if you will, California tribes. And there's a process that's just getting in place. I would assume that one of the first steps would be to make sure that tribes reach out to the Native American Heritage Commission. They'll be informing all tribes what agencies might be affecting their interests in a particular area. And then you'd be contacting those public agencies, identifying somebody who would be the contact to then, anytime they do any kind of CEQA action, before they get to the first question, is there a potential significant impact, they're required to contact the tribe. The tribe then has 30 days, I believe, to say whether they think there's an issue with one of their cultural resources, including sacred sites, and there's, of course, a long list of the kinds of interests you'd have. And then the lead agency would say, okay, thank you, and conduct consultation with you to try and determine the magnitude of the effect, and then the mitigation as appropriate to address the significant impact. So a process that obviously just signed into law, so the state is going to, I'm sure, take a little bit of time to figure out exactly how to implement it. I know the CEQA guidelines, there's a directive there to have them amend that, and as well as a directive for the Native American Heritage Commission to also develop a process in creating a list of the tribes. But it's not just federally recognized. It'll be both federal and non-federally recognized tribes. So a mouthful on your CEQA process. So the question, the CEQA process is initiated, when is the CEQA process initiated for the board? That's correct. It's when we get an application where there's a change in the point of diversion or place of use for the water rights side. The CEQA process probably would have already been initiated by another agency who is either assisting in funding that project or in helping propose the project. So for larger water development kind of projects, it's rare for the State Water Board to be the lead agency. There's usually another state agency or local water district that's involved in the planning of it. And from a CEQA standpoint, the agency that owns the project, that is proposing it, those kind of things, usually they're the lead agency. And then we get the application, and we're what's called a responsible agency in that instance. And I think in that case, the CEQA process would have already started, and the lead agency would ask us to get involved, anticipating the application. Do you have a follow-up for the CEQA? Yeah. You want to, Geeta, do you want to?
The gentleman behind you has been waiting, and then I'll come to you.
Oh, mine was completely off, not on what they're on right now. And
Okay.
I paid you.
You, okay.
Yeah, all right.
The problem with the explanation that you just gave is that in this particular project, the enlargement of Shasta Dam, there is no state agency involved because Public Resources Code 5093.542 specifically prohibits it because it would impound an enlargement of the dam would impound the free flow of the McCloud River. And so that's under Public Resources Code 5093.542. So in that particular case, now that the federal government has already finished their EIS, EIR, and will be submitting it to the Secretary of Interior in December, and it's anticipated that it'll be sent to Congress for approval of one of the preferred alternatives by March of next year. in that kind of a situation where they're just playing cowboy or loose gun away from the state, where does the State Water Resources Control Board come in then? Has there been an application for an increase in on their water rights allocation? If not, when will you guys address that? And when you do address that, who then will initiate the CEQA process, because that will not have been done yet and has not been started?
I don't know the answer to the first question, which is if we have an application in, and I'll turn to, no, we do not. So there's been no process initiated with the State Water Board. Now, you said that there was an EIS, EIR already done.
Yes.
So the EIR part is the CEQA part, and I don't know anything about this particular project, so I'm going from your representation. So if it was both a joint CEQA-NEPA document already prepared, when they submit the application to us, they'd also, hopefully they've already had some discussions with us, and again, I don't know anything about this process. But so then when the application comes in, we'd need to make sure that we complete our CEQA process prior to making a decision. And so that might mean looking at that document and saying, is that appropriate for this decision making? Do we need more information in order to comply with water code standards? And is there anything that's changed that we need to add to the record in order to complete our CEQA process?
Good. Be ready then, because it's not a NEPA CEQA document.
Okay.
There's been no
Okay.
CEQA done.
Okay.
There has been no NEPA done.
Ah, okay. So then we might be the lead agency in that instance, and we'd have to do the CEQA process as the lead agency. As part of that, we'd be going through this new process for consultation. For the tribes that have contacted us, asking that there's, when a CEQA decision has been, or an application is put in, that we contact them and start the AB 52 process. So that'll be part of it as well.
Aren't all these projects done by the Bureau of Reclamation? Because that's all we've talked to at Big Sandy was with the Bureau on Temperance Flat.
Well, certainly if it's Central Valley project stuff, that's the Bureau of Reclamation. But many times there's a state or local agency that is working in conjunction with the Bureau, because the Bureau is delivering water somewhere in California, right? So many times, not always, but many times there's a state or local agency that is somehow involved, and it's just trying to figure out if they have discretion, if this is a project, if they do trigger CEQA as part of that.
So, time check. It's 3:32. We're going to reconvene back in here at 4:15. Mariana has a half hour before she has to leave. So I know there's lots of interest and questions, and some folks will not be able to participate in the groundwater session later this week. So I invite those of you that do have specific questions on the groundwater stuff or other things to come up and talk to Mariana in the next half hour. The rest of you to go outside, stretch your legs a little, go to the various stations, check out the ERIM system, check out funding opportunities for tribes. There's water quality monitoring information there, bunch of information on beneficial uses, and then come back in here, reconvene at 4:15. Thank you. Yes? Yes. Yeah.